If you refuse to take a breathalyzer in the Commonwealth of Virginia, there are consequences. First, to understand that, we need to understand kind of what implied consent stands for in Virginia. Virginia says if you're operating a motor vehicle on its highways, which is essentially all public roads, and you're placed under arrest for DUI or a similar offense, then at that time you have given consent to submit to the breath test or blood test. If you refuse to take the breath test or blood test at that point, then there are consequences. For the first time, it would be a civil violation and you lose your license for 12 months. Now, understanding that at the end of 30 days, you do have the right to petition the court to ask for a restricted license. The restricted license will allow you to drive, but will place restrictions on when you can drive and when you can't drive. If you commit the refusal and within the previous 10 years of that refusal, you've been convicted of a DUI or similar offense, it'll be a Class 1 misdemeanor and you'll lose your right to drive for 3 years. Now understand that many people think that if you refuse to do the blood or breath test, the Commonwealth's unable to convict you of DUI. And while it makes it more difficult for the Commonwealth to convict you of DUI without the blood or breath test, they can still maintain a conviction of DUI through other evidence. So it's not always in your best interest to refuse those tests.